I think we've got an accommodation, and for those who were not present, there was some real concern about the two issues raised in the analysis, one being the statute of limitations and the other being the whole question of forum shopping. Again, we've been negotiating outside of the room with Assemblymember Holden, and he will come back and we'll put that on the record and then vote and see what we can do to deal with the issues on what is a very important and heartfelt concern dealing with genocide that I think we'd all like to find a way to get a good bill. My Zadie feels better now. Okay. So we are going to lift the calls.
Do you want to lift the calls only for Martin, or you want to wait to see if Hertzberg's coming back down?
Oh, did he just leave as well?
Yeah. So
let's give it a minute. See if we can. Yeah.
Can I just ask how the chair voted item 2?
the chair was out of the room, so the measure was taken.
So the chair will be voting in support. Yes, with the significant amendments taken. Yes, yes.
Everybody's initial.
Busy day. Deja vu. AB 15, take 2.
Calling file item 1, AB 15, with Assemblymember Holden present. We have been discussing this measure. The Assemblymember has agreed to remove from the bill the statute of limitations lifting that goes back to 1900, so removing that from the bill. He has agreed that we will work together to find a way, if we can, to address the forum shopping question so that we can find a way to address the concerns that were expressed by the committee and yet deal with the legitimate questions about how we can allow for victims to be able to redress those grievances in dealing with the forum shopping question. And the agreement is that if we will pass this bill out of committee today, Senator Leno will move for reconsideration. Those amendments will be taken, that representation will be made, and the author will accept those amendments, and then we will do pass as amended to the Appropriations Committee. It's the first time that one is new to me, but I think that that is the appropriate way to address this, and I certainly will take a minute if you'll just. We have back file item 1, AB 15 by Assemblymember Holden. We have been working on negotiating some of the concerns that were articulated both in the analysis and then during the discussion. So the agreement that we have is that Assemblymember Holden will remove page 6, on page 6, striking lines 5 through 19 in their entirety as suggested on page 12 of the analysis, so that it will be prospective only, and that Assemblymember Holden has agreed to commit to working on the forum shopping question under CCP 361. We will agree to pass the bill out of committee. There will be a motion to reconsider by Senator Leno. Then those amendments will be taken, and a representation made that should we not be able to resolve that forum shopping question, that the bill will not move out of appropriations. And Assemblymember Holden, a man of his word, I think we will all support that effort. And I personally want to thank him for, and all of those who've been working to try to get something, because I think we all really would like to see something happen here, something positive. So with that, does that concur with your understanding, sir?
It does.
Great, great. So what we will do is we're going to lift the call. I will go from a no to an aye vote. That will be the chair's recommendation. And then Senator Leno will move for reconsideration. We will then vote on that motion. The author will officially accept the amendments, and then we will move the bill to pass to approbes as amended. Okay, so Madam Secretary, please lift the call and call all members, please.
Okay. Anderson, Hertzberg. Aye. Hertzberg, aye. Leno.
Aye.
Leno, aye. Monning. Aye. Monning, aye. Are you changing? Yes. Chair is a no vote.
No to aye.
Chair is changing her vote from no to aye. So it's 6-0.
All right, the bill. All right, and Senator Morlock had already voted for the bill as an aye.
Aye to aye.
All right, we have aye. And then we had Senator Wachowski was already an aye. So we have 6-0. That bill is out.
Madam Chair, I move for reconsideration of a favorable vote.
All right, that is the motion. There will be a vote on that motion. Madam Secretary, please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Aye. Morlock, aye. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wachowski.
All right, that motion has 5 votes. It is out. The author, will you just confirm that you accept those amendments that have been offered, and that we will continue that discussion in Assembly Appropriations on the other?
As stated on the record, I support the recommendations and the amendments as the chair has outlined, and with great enthusiasm, we'll look to work with her as we move the bill to appropriations.
Very good. Thank you very much. And if we are unable to resolve that, then the bill will stay on Senate approach. Very good. All right. So that is a motion do pass to appropriations as amended by Senator Leno. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Morlock, aye. Anderson? Hertzberg? Aye. Hertzberg, aye. Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wachowski. That's 5-0.
All right, we will leave that bill on call. You have 5 votes. That bill will be out once we call Senator Wachowski. And I think that does it. And I want to thank you very much to you and your staff and to the authors for your effort.
Thank you.
That's true. Especially in one committee with only 7 members.
We've heard this
very
for
good.
15 years. We just got, this is
Thank
history
you.
that's being made today.
Thank you very much. That's right. Thank you, Assemblyman. We really appreciate your efforts and the willingness to work on this bill. So thank you, sir. All right.
You want to lift calls, or do you want to do, some of our low staff has got a letter?
Let's have him come in. All right. We have a letter from Assemblymember Lowe to allow his staff, Tatum Holland, to present AB 883. No, you're going to be nice to her. I know this lady. All right. The letter respectfully requests she be able to present this bill on his behalf in today's committee hearing. He is still in Senate Transportation presenting a bill. So with that, Ms. Holland, would you like to proceed? And this is file item 8, AB 883. Please proceed.
Well, thank you, Madam Chair, and thank you, Senators. The Assembly member is still in Transportation Committee, so he apologizes that he can't be here himself, but I appreciate the accommodation. So first, we would like to accept the committee's clarifying amendments as outlined in the analysis. AB 883 prohibits employers from publishing or posting a job advertisement that disqualifies an applicant who is currently or was at one point a public employee. A new trend in employment practices has surfaced, one that requires an applicant for employment to not be a participant of a governmental retirement plan. Consequently, qualified job applicants are now being discriminated against. AB 883 levels the playing field for job applicants by allowing their credentials and qualifications for the position to speak instead of their status as a current or former public employee. With me today is Megan Brightwell on behalf of the California Professional Firefighters. I would ask for your aye vote.
Thank you very much.
Thank you, Madam Chair and members. Megan Brightwell on behalf of the California Professional Firefighters, pleased to be the sponsors of this bill. As Tatum noted, this is sort of a new practice that we're seeing with employers and specifically impacting our members. You know, we find it a little bit ironic and also a little bit frustrating that the same job qualifications that you strive to have to apply for jobs in the future is the same experience that is barring you from applying from a job altogether. We think that, you know, especially in positions like firefighters, for example, where they're highly skilled, highly trained positions, that experience should go a long way. So it's not only a disservice to the applicant, but also to the communities that they're hoping to serve. So we think it's a good bill, and we respectfully ask for your aye vote. Thank you.
Thank you. Next witness.
Thank you, Madam Chair. Members, Mitch Seaman with California Labor Federation, also here in strong support of the bill. It's incredibly unfortunate that this kind of discrimination does exist, but the fact is that it does, and we see this bill as a modest attempt to deal with it. We urge your support.
Thank you. Other witnesses in support? Oh, I see some witnesses in opposition. Would they come forward, please? Just a hunch. All right. Good afternoon.
Good afternoon, Madam Chair and committee members. Jennifer Barrera on behalf of the California Chamber of Commerce, and we are opposed to AB 883. From our understanding, there is no example of any discrimination having occurred in the private sector against applicants who are former government or public employees. And so to the extent that we are not actually addressing any known discrimination, we believe that it is prohibiting us from inquiring into an applicant's work history and setting us up for potential discrimination litigation. Although the bill does not explicitly prohibit an employer from looking into somebody's work history, what it specifies is that you cannot take any adverse employment action against an employee based upon their prior status as a public employee. That means that if an applicant submits an application to one of our employers and we ask for their work history and they identify that they're a public employee or that they previously were a public employee, we at that point have knowledge of a protected status. And if we ultimately do not hire that applicant for some other reason not related to that public employee's history as a public employee, we could still be set up for a discrimination lawsuit. We do not believe, unlike other protected classifications such as age, race, or marital status, that this is a subject area that we can easily navigate away from in the application and interview process because somebody's work history is very relevant to us. And so to the point that it is not addressing any known discrimination and is simply setting us up for additional litigation, we have concerns with including the private sector in this proposal, and for those reasons we are opposed.
Thank you. Next.
Mr. McKaylee, on behalf of the Civil Justice Association in California, we share the same concerns that were outlined by the Chamber. We would request on, I think, page 2, line 3, that it be limited to public employers. We've raised previously with this committee, as we did in the prior, that we're very concerned about providing new bases for Private Attorneys General Act litigation in the state, which, again, we've seen an exponential growth of over 400% just in the last 8 years since it was enacted. So we would like to see the bill narrowly tailored. In the prior committee, I think the author or the sponsor only cited one example in the public sector of this being used in an advertisement for a job opening. Thank you.
Thank you. Would you respond to the 400% increase in litigation on what issue?
That have been filed since its enactment in 2005.
I'd be very interested, where did you get that data? Because it's so hard to get data on anything. What?
That's tracked. There was a story in 2014, April 2014, I think. It's cited in your committee analysis in AB 1506. We went from about 750 lawsuits in 2005, the first year that PAGA was enacted, to roughly 3,300 or 3,500 8 years later. And that's detailed in Tara's analysis in AB 1506.
Okay, thank you very much. Yes, Senator Monning.
Thank you. So as I read this, it seeks to prohibit in the advertising for a job position. Correct me if I'm wrong, but it doesn't preclude making a full inquiry of the applicant's qualifications, work history,
Correct.
et cetera. Is that?
Yeah, correct. It only prevents an employer from screening out an applicant prior to engaging in any kind of application or interview process.
Right. So then again, the concerns voiced by the opposition that this potentially creates a cause of action or at least lawsuits for not hiring somebody who comes from a prior public employment position. There's nothing in this that creates that cause of action against an employer. Is that correct? This goes to trying to not have people blocked at that
At the first job posting.
Stop.
Exactly.
Thank you.
Thank you.
Chair, doesn't that result in a 17-200 cause of action? Couldn't you, that's unfair business practice, sure. You could make a 17-200 claim on that. If somebody was out there and made that violate, like we passed this law, it now becomes the law of the land, right? wouldn't it serve as a basis for 17200 Business Professions Code 1700 Fair Business Practices or labor? No, let's assume somebody completely violates the law.
Why don't you ask that question to the witnesses here, rather than to Senator Monning?
Your counsel over here. It's my lawyer. Yeah.
Okay.
Let's answer that question.
I'm not familiar with Business and Profession Code 1700.
Why don't we have the opposition come up before they come up anyway? All right, you have the invitation. Do you have any answers for that? I know.
No, but I'm happy to look into it as well.
All right, go ahead. I think Ms. Barrett.
My understanding is it would be a basis for an unfair competition claim under the UCL 17200, as well as a claim under the Private Attorney General Act, because it specifies in the PAGA that any violation of the Labor Code, which is where this bill is proposed to be housed, is subject to a PAGA representative action under the Labor Code. So you have multiple avenues of litigation under there. That's only one portion of the bill. There's a separate portion of the bill that says an employer cannot take any adverse employment action against an applicant based upon the applicant's status or prior status as a public employee. And that was what I was getting at in my testimony to say, from our perspective, it definitely does.
And can I just ask another question, Madam Chair?
Please.
Yeah, I mean, I just want to, the thing is, look, big co's have a zillion people out there that read all this stuff. Nobody in small businesses read this stuff and know what we do, except they're worried about workers' comp and they're worried about labor commissioners, and that's about it, right? We pass all these laws. The only thing I would do, I don't have a problem in the notion of the act and what you're trying to accomplish, but I'd like to give somebody an opportunity to correct. What I don't like is the gotcha game, right? We set a set of standards as a state. We think it's an important set of values that we want to achieve. So if somebody violates the law in the first instance, you give them 30 days or 5 days, I don't care what it is, to correct. Then they keep making the mistake, then you zets them, right? But you give them a window and don't all of a sudden create a situation where somebody can, who doesn't know the difference, some small co does this and they don't know the difference. That's all. I mean, I'm all for the values. I don't have a problem with that. I just don't want the gotcha game where somebody ends up getting a lawsuit. And the reality, when you're a little business and somebody threatens you and shows you this law and you violate it, you have a heart attack and they say, send me $2,500 and you do, right? And so we end up, as a legislature, end up getting people who are at the core of what our economy is. 73% of all businesses are 10 employees or less, and we put them in harm's way. The big guys, they all have all these special people that figure all this stuff out and pay them big salaries. So that's my only thought. I don't know how you do that, but I just want to be sensitive to the small business person. And then if they're bad actors, then you zets them. That's a defined term.
Well, okay. Would you like to step forward and respond to that? We're at a little disadvantage because the Assembly member isn't here, and this is a good, frankly, this is, I think, a very healthy discussion. So if you could help us out here.
Just wanted to mention that employers do have a right to cure under PAGA, that there are two separate violations under PAGA. Some can't be and some can be. And under this bill, because it's not specifically added to the sections of PAGA where an employer wouldn't have the right to cure, an employer would have the right to cure if they were.
Can I add on to that?
Please.
I agree with his statement. There is no right to cure under a 17200 claim, and while I do believe there would be an opportunity to potentially cure an advertisement that Senator Monning was referencing, I don't know how an employer would ever have an ability to cure not hiring an applicant. Like, how do you cure that? Do you offer them a job, even though you didn't hire them based upon some other position? So I think the opportunity to cure is under PAGA, but I don't know how that realistically would be implemented for something like this, and it would not apply to a 17200 claim.
Thank you. Is there a response that you can present as to the issue? We've now got, I think, some clarity on the advertising of the position, which I think meets Senator Hertzberg's concern and one that I would share. But how then do you deal, is there some existing protocol, if you will, on the 17200 issue? How do you, are there some systems in place, or is there any data to show whether this would result in additional litigation if you just choose not to hire somebody who may have had prior public employment because you want to hire someone else? I mean, what protections exist? What would you have to prove?
Sure. So just first, this is the first time that we've been presented with the 17200 issue. So of course we would need to talk to Mr. Lowe about anything that we would consider there. of course, if Tatum agrees with me. Okay. And then also the amendments that we took way back in April were to get at this issue of an employer being able to look at previous employment history, even finding out that the applicant was a public employee or is a public employee at that time, and that not being a violation of this bill. So simply finding out that an applicant is a public employee or previously was a public employee would not be a violation of this bill. It is the adverse employment action that is covered under this bill. So we're not trying to impact an employer's ability to, look into an applicant's work history in any way. And I know that's not completely answering your question about the 17-200 piece, but I'm sort of at a...
Yeah, I suspect there is an answer, and perhaps the Assemblyman would know that. I think it's a fair question, but there are a lot of reasons people do and don't get hired. I would assume that there would be some protections or at least some criteria that would have to be met. I think, you could sue on anything. I mean, but there have to be some kind of criteria that are established.
Right. So, we removed the private right of action out of the bill, and I know that the opponents still state that the labor code is enforced by a private right of action, but it is our belief that the bill would be enforced by the labor commissioner. So if an applicant makes a claim with the labor commissioner, it would be on the applicant to prove that that would be the reason why they were not hired. But
that isn't what bothers me. I don't mind a private right of action. I just want to make sure that the standard, that we have legitimate criteria in place so that there's some roadmap that the plaintiff and the responding party have available to them. Senator Hertzberg?
Quickly, Madam Chair, my inquiry was narrower than that. Section 1, 432.6 on page 2 of the measure says an employer, including a public employee, shall not do any of the following. It lists publish, communicate, make an advertisement, goes through what that means. And then Section C says the section shall not be construed to prohibit an employer from asking questions about their background, their skills, and those questions. I wasn't even looking to the issue. I just think it's so innocent when somebody makes a mistake. They don't even know it's against the law, and they're never going to know it's against the law to write an advertisement. I just wanted to give them a notice, and then if they continued it, then to nail them. Because I don't think most employers in the state of California are going to read this who are 10 employees or less. I just want to give them a one-shot deal to have a window if they advertise. I think the issue of complexity with respect to employer or not employer is a matter of evidence before the labor commissioner, which I don't want to touch.
Right, but I think what we heard testimony that there is a right to cure in the advertising portion of the bill.
Where?
Under existing law.
Right. Under PAGA, you do have the right to cure as an employer, assuming that the section of the labor code isn't in one of the ones that's specifically enumerated as ones that.
I think you got to ask. I think you got to look at the cross references because I think that probably is true, but it should have the right to cure. What does that mean? I just make it clear. That's all. If it's there, it's there. I'm okay, but I don't.
And that's something that we're happy to look into further. And I think your idea of a corrective action plan or some sort of corrective action for employers is something that I'm definitely happy to talk with the Assembly member about. And we've been working with the opposition the entire time and have had.
So let's do this. Given the fact that the Assembly member isn't here, these are good questions. We don't necessarily have the answers. I would like to propose that we put this over. We do have time. We can put it over a week. We'll have the Assembly member here. You heard some of the questions that were asked. Let's get some answers to them. I think that they're good questions, and I think there's a little confusion here that he would hopefully be able to assist us in answering. Unless there's any other questions, perhaps we could do that. Is there any objection to just simply continuing this a week? All due respect, I think this is, some good issues raised, and then we'll try to narrow that down. And I would like to know too what those criteria would be. Again, the goal is not to confuse or to force more litigation. It's to protect people, both the employee and the employer, and that would be, I think, the basis for the discussion next week. So let's do that. We'll continue this item a week and see if we can't get the Assembly member maybe first up. That way he can run and do those other things. Very good. All right. Oh, he's got an Uber bill. It serves him right. See, that's, all right. So I think we're all done with our calendar. We're going to lift calls, and thank you all very much for participating. So let's.
I want to talk to you about the Wagner bill on the floor Thursday morning. The one that we continue.
He's got two.
All right. So let's go ahead. Let's lift the calls. We're going to go through the full calendar. And Madam. All right. Let's. The first item will be the consent calendar. The vote is 4-0. Please call the absent members on the consent calendar.
Anderson, Hertzberg. Consent. Consent. Hertzberg, aye. Wykowski. Aye. Wykowski, aye.
6-0, the consent calendar is out. File item 1 by Senator Holden. We have gone through a procedure where there will be amendments. It's come back. We have voted on the bill. We moved reconsideration. Amendments were taken. And then we voted again on the bill. The bill count now is 5-0 in support. As amended, that's right. So Senator Wykowski, this is to pass as amended to Senate appropriations. Please call the absent members.
Anderson, Wykowski.
Aye.
Wykowski, aye.
6-0, that bill is out. Next item is file item 2, Assemblymember Gatto, AB 83. The vote count is 2-1. Chair has not voted on this item. The chair will be voting aye. Please call the absent members.
Jackson.
Aye.
Jackson, aye. Anderson. Monning. Aye. Monning, aye. Wykowski. Aye. Wykowski, aye.
That is 5-1. That measure is out. The next item is file item 3, Assemblymember Gatto, AB 139. Do pass as amended to Senate approbes. The vote is 2-0. Chair not having voted, chair will be voting aye.
Jackson. Aye. Jackson, aye. Anderson. Hertzberg. Aye. Hertzberg, aye. Monning. Aye. Monning, aye. Wykowski. Aye. Wykowski, aye.
All right, 6-0, that bill is out. File item 4 is part of the consent calendar. File item 5, AB 551 by Assemblymember Nazarian. The vote count is 2-1. The chair voting aye. Please call the absent members.
Anderson, Hertzberg. Aye. Hertzberg, aye. Leno. Aye. Leno, aye. Monning. Aye. Monning, aye.
5-1, that bill is out. File item 6, Assemblymember Hernandez, AB 621. The vote count is 3-0. The chair voting aye. Please call the absent members.
Anderson, Leno. Aye. Leno, aye. Monning. Aye. Monning, aye. Wykowski. Aye. Wykowski, aye.
6-0, that bill is out. File item 7, AB 709 by Assemblymember Gibson. The vote is 2-1. The chair voting aye. Please call the absent members.
Anderson, Leno. Aye. Leno, aye. Monning. Aye. Monning, aye. Wykowski. Aye. Wykowski, aye.
All right, the vote count is 5-1. File item 8 is continued to next week. File item 9, Assemblymember Chu, AB 960. The vote count is 2-0. The chair voting aye. Please call the absent members.
Morlock, Anderson, Hertzberg. Aye. Hertzberg, aye. Leno. Aye. Leno, aye. Monning. Aye. Monning, aye.
All right, the vote count is 5-0. That bill is out. File item 10, AB 964 by Assemblymember, no, I'm sorry. Did I get that right? Yes. File item 10, Assemblymember Chow. The vote count is 2-1. The chair voting aye. Please call the absent members.
Anderson, Leno. Aye. Leno, aye. Monning. Aye. Monning, aye. Wykowski. Aye. Wykowski, aye.
All right, the vote count is 5-1. That bill is out. File item 11 was pulled. File item 12, AB 999 by Assemblymember Daley. The vote count is 4-0. Chair voting aye. Please call the absent members.
Anderson, Monning. Monning, aye. Wykowski. Aye. Wykowski, aye.
6-0. That bill is out. File item 13, AB 1028 by Assemblymember Bonta. The vote count is 4-0. The chair voting aye. Please call the absent members.
Anderson, Monning. Monning, aye. Wykowski. Wykowski, aye.
Not an editorial comment, I hope. All right.
6-0 is out.
6-0, that bill is out. File item 14 is part of the consent calendar. File item 15, the same. File item 16, AB 1197 by Assemblymember Bonilla. The vote count is 3-0. The chair voting aye. Please call the absent members.
Morlock, Anderson, Hertzberg. Hertzberg, aye. Wykowski. Wykowski, aye.
5-0, that bill is out. File item 17, AB 1448 by Assemblymember Lopez. The vote count is 4-0. The chair voting aye.
Anderson, Monning. Monning, aye. Wykowski. Wykowski, aye.
6-0, that bill is out. The last item on the agenda, file item 18, AB 1506 by Assemblymember Hernandez. The vote count is 4-0. The chair voting aye.
Anderson, Monning. Monning, aye. Wykowski. Wykowski, aye.
All right, that is 6-0. That bill is out. Thank you, colleagues. We are adjourned.